Britain's immigration system faces biggest shakeup in years as MPs back sweeping border bill. MPs vote through landmark immigration bill that could transform asylum and deportation rules. The legislation would accelerate asylum appeals, restrict the use of human rights claims, recover support costs from some refugees, and strengthen the government's ability to deport serious foreign offenders. MPs have backed the government's immigration and asylum bill at its second reading, allowing one of the most consequential overhauls of Britain's migration system in years to progress to detailed parliamentary scrutiny. The vote does not make the proposals law. The bill must still pass through its committee and report stages in the House of Commons, receive a third reading, survive scrutiny in the House of Lords, and secure Royal Assent. However, approval at second reading confirms that the Commons supports the legislation's central principles and gives ministers political momentum to continue with the reforms. Sponsored by Home Secretary Shabana Mahmood, the bill covers immigration, asylum, and modern slavery. Its measures extend far beyond migrants arriving in small boats, affecting refugees, foreign offenders, families relying on human rights claims, and suspected victims of trafficking. What the Immigration and Asylum Bill does. One of the bill's most significant changes concerns how immigration and asylum appeals are decided. At present, appeals against many Home Office decisions are heard by legally qualified judges in the first-tier tribunal's Immigration and Asylum Chamber. The bill would eventually replace that system with a new independent immigration appeals authority. Cases would be decided by adjudicators who would not necessarily need legal qualifications or previous legal experience. The government argues that a broader recruitment pool would allow more adjudicators to be appointed, reduce the appeals backlog, and accelerate decisions. The proposed authority would also be able to prioritize certain cases and operate expedited procedures for people facing removal who submit late claims to remain in Britain. For ministers, this is central to breaking the cycle in which failed applicants remain in the country for months or years while successive challenges move through the system. Critics, however, are likely to question whether speed can be achieved without reducing the consistency and legal quality of decisions. Tougher restrictions on Article 8 claims. The bill would also tighten the circumstances in which migrants can rely upon Article 8 of the European Convention on Human Rights, which protects private and family life. Article 8 does not provide an absolute right to remain in Britain. Courts must balance an individual's family circumstances against immigration control and the public interest. Nevertheless, successful Article 8 claims can prevent deportation or removal, where a person has a British partner, British children, or deep connections to the UK. The legislation would direct decision-makers towards a narrower interpretation of those protections. The government's impact assessment indicates that approximately 11,700 additional Article 8 applications could be refused under the revised framework. A particularly important provision concerns families with a British child, or a child who has lived in the UK for at least 7 years. Under the proposed test, it would be considered unreasonable for a child to leave Britain only in more severe circumstances, such as where the child would receive no education overseas, would face extreme difficulty integrating, or would experience a very significant and enduring adverse effect. The practical implication is that parenthood, family relationships, and length of residence may carry less weight in future removal cases. Supporters will argue that this prevents offenders and immigration rule breakers from using family life as an automatic shield. Opponents will warn that British children could effectively be forced to choose between remaining in the UK without a parent or leaving the country with them. A single protection status for refugees. The bill would replace the existing categories of refugee status and humanitarian protection with a single legal category known as protection status. The fundamental test determining who qualifies for asylum would not change. Ministers believe combining the two categories could simplify casework and reduce administrative duplication. This sits alongside a broader government strategy that is moving away from treating asylum as an automatic pathway towards permanent residence. Previous immigration rule changes reduced the initial period of leave granted under the government's developing core protection model from 5 years to 30 months, after which an individual's continued need for protection can be reassessed. The direction is clear. Refugee protection is increasingly being presented as temporary sanctuary rather than an assumed permanent settlement route. That may make it easier to return people when conditions in their country of origin improve. It could also leave refugees facing repeated reviews, greater insecurity, and difficulty planning employment, education, and family life. Refugees could be required to repay support costs. Another controversial provision would allow the Home Secretary to recover some of the cost of accommodation and financial support from refugees who are eventually able to pay. The exact amount is not stated in the bill, but the Home Office has suggested that the sum could be approximately £10,000. Payments could potentially be collected in installments through the tax or benefit system. The government says the measure would apply only to adults who can afford the repayments, with safeguards intended to prevent destitution. Children would be exempt. And ministers have said the scheme would not operate retrospectively. Mahmoud has presented the policy as a question of reciprocity. Britain provides sanctuary and taxpayer-funded support when people are vulnerable, but those who later achieve financial stability should contribute towards the cost. The annual asylum accommodation and support bill was estimated at approximately £4 billion, with hotel accommodation costing substantially more per person than other temporary housing. The danger is that a repayment obligation could become an additional barrier to integration. Refugees starting new lives often enter low-paid employment, carry existing debts, or support relatives abroad. A £10,000 liability could delay saving, home ownership, and financial independence. Serious foreign offenders could face easier deportation. The government also intends to amend the bill to close a long-standing legal protection that has obstructed the deportation of some Commonwealth citizens who arrived before 1973. The issue gained renewed attention through the case of Rochdale grooming gang ringleader Shabir Ahmed, who is protected by provisions applying to certain long-term Commonwealth residents. Mahmoud's amendment would allow the Home Secretary to disapply those protections in cases involving the most serious criminality, including terrorism, child sexual exploitation, trafficking, war crimes, and organized crime. This would remove a significant domestic legal obstacle. It would not guarantee that every offender could actually be deported. A destination country must normally accept the person. Pakistan's reported reluctance to accept Ahmed demonstrates that legislation can strengthen ministerial powers without resolving the diplomatic and practical barriers to removal. The reform is nevertheless likely to command strong public support. Long residence protections were designed to prevent injustice against established Commonwealth communities, including those associated with the Windrush generation, not to provide indefinite protection to people convicted of exceptionally serious crimes. Major changes to modern slavery protections. Despite its title, a substantial portion of the bill concerns modern slavery. Authorities deciding whether someone is a victim of trafficking or slavery would be explicitly permitted to consider the person's credibility. Individuals considered a national security threat could also be disqualified from protections available through the National Referral Mechanism. The legislation would expand slavery and trafficking prevention orders, and slavery and trafficking risk orders. Courts could impose a risk order even following an acquittal, more police forces would be able to apply for restrictions, and electronic monitoring could be authorized. Businesses already subject to modern slavery supply chain reporting would face a stronger enforcement regime. The obligation would be extended to public sector organizations, while financial penalties could be introduced for non-compliance. These provisions could improve corporate accountability and give police greater tools to manage suspected traffickers. Yet victim support organizations are likely to argue that greater emphasis on credibility and late claims could exclude genuine victims whose disclosures are delayed by trauma, fear, or coercion. What the bill's wider implications will be. Politically, the legislation represents Labour's attempt to demonstrate that strict immigration enforcement is not confined to Reform UK or the Conservatives. Immigration remains one of Britain's most contentious political issues, while the continued use of asylum hotels, small boat crossings, and prolonged appeals has damaged public confidence in the state's ability to control the system. The bill gives the government a potentially powerful message: faster appeals, fewer successful last-minute claims, tougher deportation rules, and greater financial responsibility for those who later have the means to contribute. However, legislation alone cannot guarantee results. Faster appeals require sufficient staff, competent initial Home Office decisions, and access to reliable evidence. Deportations depend upon travel documents, international cooperation, and countries agreeing to receive their nationals. Restricting legal challenges will not resolve those operational barriers. There is also a significant risk of transferring pressure elsewhere. If hurried or poorly reasoned decisions produce more judicial review applications, the government could reduce one backlog while creating another. Replacing tribunal judges with adjudicators who do not require legal qualifications will therefore become one of the bill's most intensely scrutinized provisions. The government must show that the new authority will be genuinely independent, properly trained, and capable of applying complex refugee, human rights, and immigration law. A faster system that produces more incorrect decisions would ultimately increase costs, delay removals, and undermine confidence further. A decisive shift towards conditional protection. The bill's underlying philosophy is unmistakable. Protection will become more conditional. Permanent residence will become harder to obtain. Family life claims will face tougher tests. Failed claims will be processed more rapidly. Serious offenders will have fewer historic protections against deportation. Those who become financially secure may be expected to repay some of the support they received. For supporters, this is a necessary restoration of balance between Britain's humanitarian obligations and the interests of taxpayers, victims, and local communities. For critics, it risks weakening judicial oversight and creating a less secure, more punitive system for refugees and trafficking victims. The second reading victory means that argument now moves into its decisive phase. MPs will begin examining the bill clause by clause, where amendments could substantially alter its operation. Its ultimate success will not be judged by how forcefully ministers describe it, or even by how comfortably it passes Parliament. It will be judged by measurable outcomes, whether decisions become faster, removals increase, hotel use falls, genuine refugees receive protection, and costly legal errors decline. Until those outcomes emerge, the Immigration and Asylum Bill remains an ambitious attempt to restore control, not proof that control has already been restored. Search engine optimization title: MPs back Immigration and Asylum Bill in major border law overhaul. Search engine optimization description: MPs have backed the Immigration and Asylum Bill at second reading. Discover what the legislation changes and how it could reshape asylum appeals, deportations, refugee protection, and human rights claims across Britain. Spotify description: MPs have backed a sweeping overhaul of Britain's immigration and asylum system. We examine the new appeals authority, tougher deportation rules, restrictions on human rights claims, refugee support repayments, and the implications for Britain's borders.